Shalom YouTube. This is your art, Yaz Magnified, coming back with another video. This video is titled Complaint versus Claim. So with that being said, let's get to the subject matter at hand. Okay guys, so it's some confusion about the difference between the complaint and the claim and which one holds more weight in court or just period. Me, this is not legal advice, because I'm not a lawyer. But when I do everything, I always state a claim. I never go into any of courts or any legal proceedings with a complaint, because a complaint is not strong enough for me, And plus, a complaint must state a claim, but a claim doesn't have to state a complaint, because a claim is more powerful than a complaint, And basically, a complaint means to complain. Going to court. You can complain about the wrongdoings, but in your wrongdoings, you don't state a claim. And when you don't state a claim, you don't state relief, which the claim could be adjusted. You see what I mean? So, with that being said, let's get to the definition for the word complaint or complainant. Complainant, one who applies to the courts for legal redress by filing complaint, i.e. plaintiff. We're going to get to the definition of what plaintiff means by the end of this video. It says also one who instigates prosecution or who prefers accusations against suspected person. You see? So it's all accusations. You don't want accusations, by being a complainant. You want to be the claimant when you state all truths and facts. It's hard to argue the facts and argue the truth when there are truth and there are facts. You see? But let's go to the definition of complaint. Complaint, the original or initial pleading by which an action is commenced under codes of rules of civil procedure. Right? Then it says, e.g., Federal Rules of Civil P3, the pleading which sets forth a claim for relief. See? So you got to set forth a claim even when you're doing a complaint. You got to put a claim in for relief. If your complaint don't have a claim in it, then it's pointless. It's a waste of time. You see? It don't hold no weight. So a complaint without a claim holds no weight. You see? So why not just be the claimant instead of complaint or the complainant? It just don't make no sense. Okay, here it is. Such complaint, whether it be the original claim, counterclaim, cross claim, or third-party claim, shall contain, and it tells you what each complaint should contain. But it must contain a claim. You see? Let's read one. 1. A short and plain statement of the grounds upon which the court's jurisdiction depends, unless the court already has jurisdiction and the claim needs no new grounds of jurisdiction to support it. So again, they need claims to even get jurisdiction over you. You see? So let's go number 2. A short and plain statement of the claim showing that the pleader is entitled to relief. You see? So your claim must be written upon which relief can be granted. You see? So you just can't go in there and just be stating a bunch of nonsense on a piece of paper and expect that to work. It's not going to work that way, guys. And definitely do not go in there using their paperwork to try to file your claim, because their paperwork not made for you to win this type of battle. Yeah, they'll help you fix a flat car tire or something if you hit a pothole. You can file a claim against the city for that. But in child support, you really need to do your own paperwork when you file a claim, and then you enter that into the courts when you file in your courts, and you coming in as the claimant, not the plaintiff, and not the complainant. You see? But let's go a little bit forward. Let's go to 3. 3. A demand for judgment for relief to which it deems himself entitled. Relief, an alternative, or of several different types may be demanded. You see, guys? So The whole thing is basically about demanding a relief. But how do you demand something? By a claim. You see, you must state a claim. So just file your claim, not a complaint. But let's go a little bit forward. And that's Federal Rules Civil Procedure, page 8A. The claimant, together with the summons, is required to be served on the defendant. Rule 4. See also counterclaim, cross-claim, supplemental complaint, third-party complaint. Okay, guys? So now we see that a complaint must have a claim in it. But let's see the definition of claim to see if a claim must be written as a complaint. We're going to see which one holds more weight. So let's go. Claim, right here at the bottom. To demand as one's own or as one's right. See? To demand. So you need your claim. You don't need to file a complaint. File a claim. Here it is. To assert, to urge, to insist a cause of action, means by or through which claimant obtains possession or enjoyment, let's scroll up top, or enjoyment of privileges or thing, demand for money or property as of right, e.g. insurance claim. So when you state your claim, you're stating your claim for property or money, you see, that they owe you because you're stating your claim. And that's going to be your relief upon which you demand for the hardship or the injury caused by who? The child support agency, guys. But let's go a little bit further. With respect to claims to a negotiable instrument of which a holder in due course takes free, the term claim means any interest or remedy recognized in law or equity. You see, guys? It's so clear. You got to file your claim, but not a document that they give you to file. No, you write your own claim. But let's continue. That creates in the claimant a right to the interest or its proceeds. You see, guys? But let's go forward. Right to payment, whether or not such right is reduced to judgment, liquidated, unliquidated, fixed, continuant, matured, unmatured, disputed, undisputed, legal, equitable, secure or unsecure, or right to an equitable remedy for breach of performance, if such breach gives such to a right to a payment, whether or not such right to an equitable remedy is reduced to judgment, fixed, contingent, matured, unmatured, disputed, undisputed, secure or unsecured, bankruptcy code, subsection 101. But you see, this is how you get your remedy in equity. You see, guys? This is how you get your remedy in law and in equity. By what? Stating a claim, upon which relief can be granted. You must state a claim. Not go in there and complain, State your claim, guys. But let's go a little bit deeper. Right here, guys. I copied this from one of my books. It says, let me stroll out a little bit. It says, the Supreme Court has been giving us hints for years on this issue when they said there is a very simple remedy from a belligerent claimant to establish his own common law rights. The Supreme Court has ruled again and again that for a citizen to claim common law rights, he must, 1, do it himself, and 2, be a belligerent claimant at law, which they said belligerent claimant at law. They are saying you just make yourself the claimant in your suit at law by attaching at law to the word claimant on the writs. Never move a case as a defendant. The root definition of plaintiff is, here we go, guys, a person who brings an action, the party who complains, or sues in a personal action and is named on the record as Black Law's first edition, emphasis added. This is very important because a sovereign never complains. Sovereigns only makes claims. You hear that, guys? So with that being said, it don't take 25 to 35 minutes to make your point, you know? It don't take hours for you to, show the truth. The truth don't take long to show, you know? So people who making all these long minute videos, why? It takes a long time to tell a lie. It takes no time to tell the truth. So with that being said, y'all be blessed. Continue to fight. File your claims. Do not file a complaint. So with that being said, this another gem band drop. Y'all be blessed. Shalom, YouTube.